protecting and preserving your constitutional right to bear arms. It's Gun Radio Utah. Here's your host, Clark Aposhian.
And welcome back to Gun Radio Utah. There are no apologies, and because I'm excited to have my next guest on, I want to get right to it. I want to introduce the audience to Richard Samp, Senior Litigation Counsel for the new Civil Liberties Alliance out of Washington, D.C. And Richard, welcome to Gun Radio Utah.
Yeah, Clark, it's my pleasure to be here.
Oh, thank you. So you were able to get me a seat for the hearing that occurred on Thursday in front of Justice Jill Parrish with District. So the Utah Circuit, she's part of the 10th Circuit Court. And can you explain to our listeners, so it was on Aposhian v. Garland, which is for folks that, that listen to the show, they know essentially it's a bump stock case, but it's about so much more than bump stocks, isn't it?
It is. One of the major problems in Washington is that the executive branch, regardless of who is president, seems to think it's their right to write the laws, and if they don't like the way the law reads, they change it, and that's what happened here. For many, many years, ATF said that bump stocks were not machine guns, and then in 2018, the Trump administration said, well, we think it would be politically convenient to change our mind on that, and so we're going to rewrite the law. And so our contention all along here has been that it is up to Congress and not the president to decide what the law is, and that's really what's at stake in this case.
So what are the pitfalls, then, of allowing an executive agency like ATF or EPA or something like that to essentially bypass Congress and write their own laws?
Well, it's particularly inappropriate when you're talking about criminal statutes because it's the executive branch that prosecutes crimes. And so if you allow the same person both to write the law and to prosecute those alleged to have violated the law, you're allowing a single person to be both prosecutor and judge, and that really is an invitation to tyranny because we really need to have separate law writers and enforcers of the law.
So with the new Civil Liberties Alliance, this is not new ground for you folks. You have been fighting for appropriate executive, administrative type behavior for quite a while. And the bump stock case, Aposhian v. Garland, this isn't your only bump stock case. You have some others that have actually been moving with a little bit more progress. Is that right?
That's right. As a matter of fact, we have one that comes from Texas, and there are two others besides our Texas case that are now in the Supreme Court. We won a decision by a vote of 13-3 by the Fifth Circuit Court of Appeals. That's the court that oversees Texas, saying that ATF had acted illegally when it changed the definition. There's that case. There's also one that comes out of the Sixth Circuit, which is in Cincinnati. That case is named Hardin, and in that case, the court said, well, we think the statute is somewhat ambiguous, so we're going to decide the interpretation in favor of the potential criminal defendant because under what's known as the rule of lenity, you're supposed to give the tie in favor of the individual citizen and not the government. And then there's a third case that comes out of a federal court here in D.C. that rules in favor of the government. So there are three cases now coming up before the Supreme Court. The court at the end of October is going to have a conference and decide whether to hear any of those three cases on the merits. And given that there is a split of authority with two cases going our way and one case going the other way, almost surely the Supreme Court at the end of October or early November is going to grant review because that's what the Supreme Court generally does. It hears cases in order to resolve splits among the lower courts.
Exactly. Yeah, like you said, that's exactly what's happening. In addition to the two circuit court cases, there was also a military case that went our way. Isn't that right?
That's right. there is a Court of Criminal Appeals governing military courts, and it ruled that the ATF's interpretation was improper, and as a result, they overturned the criminal conviction of a Marine who was found to be in possession of a bump stock. Well, the government never appealed that decision. So, as things stand right now, it is totally legal for a member of the armed services to have a bump stock in his or her possession on a military base, but in other parts of the country, as in, for example, Utah or in the District of Columbia, it's illegal to do so.
Wow. Exactly. Okay, so we had a hearing on Thursday, and forgive me if I get this wrong. It was basically a motion for summary judgment by both parties, the ATF or the United States government and us. We were both asking for a summary judgment in our favor. Can you tell us what happened and just in a nutshell why you think it occurred?
Well, first of all, there was no need for a full trial because there really aren't any disputed facts. It's just disagreement as to what the law means. The judge said, this case has already been up before the 10th Circuit Court of Appeals in Denver once before, and that court said,
how powerful is the Cox network? So powerful that one day the internet will let your doctor perform miracles from thousands of miles away.
Connecting to remote operating room.
Giving a whole new meaning to the term house call.
Operation complete.
The Cox network. With gig speeds everywhere. It's internet built for tomorrow, today. Cox, bringing us closer. In Cox serviceable areas, speeds vary and are not guaranteed. Cox terms apply. Other restrictions may apply.
As a major research institution, Arizona State University offers the most online bachelor's degree programs, along with world-class faculty and dedicated support. Discover why ASU is ranked #1 in innovation for 9 consecutive years. Tap to learn more.
Any tie ought to be interpreted in favor of the government, which, of course, is the exact opposite of the way we see things. But that's what the 10th Circuit said in a decision 3 years ago. So as far as the district judge was concerned, she was bound by that decision to continue to rule that the tie goes to the government. And she then said, I think this statute is somewhat ambiguous. And so given that it's ambiguous, we're going to rule for the government as the tiebreaker.
See, and to me, being a layperson on this, as I understood the Chevron doctrine, which allows for agencies to interpret ambiguous things, that they have to basically say, we want Chevron deference, or we want that kind of an ability to do that. But the government has continued to say they don't think it was ambiguous. Is that right?
Well, they say it's not ambiguous. More importantly, they have said we don't think that this is the type of case in which government deference is warranted. And despite saying that, both the 10th Circuit and the district court judge in her decision yesterday said that yes, we are going to apply deference to the government's interpretation, which is highly unusual. The Supreme Court has never said that it's appropriate to give deference to the government when they don't ask for it. And interestingly, the Supreme Court, in a totally unrelated case, is going to decide this coming term whether just to overrule the idea of ever applying Chevron deference. I think many people, myself included, think it ought to be totally up to the courts to decide what the law means and not to defer to interpretations of the law by the government.
I mean, exactly, because we have learned by sad experience that they don't do well. The administrative agencies don't do well. Everything from ATF to EPA and that have not done well exercising any restrictions on Chevron. So what happens here? What happens with my case at this point?
Well, we go back up to the U.S. Court of Appeals for the 10th Circuit in Denver. And I think it's important to keep the case going because you never know what's going to happen in other cases. However, Clark, I hate to tell you, I think that your case is probably going to be superseded by whatever the Supreme Court does, because I think that the Supreme Court is likely to hear one of the pending cases, and when it does, and when it issues its decision, whatever that decision is, and I'm reasonably confident it will be a decision in our favor, but whatever the decision is, that will be binding in your case.
And ultimately, ultimately we are anticipating a win, whether it's my case or one of your other cases, which will apply to it. So we've been listening to Richard Samp, Senior Litigation Counsel for the New Civil Liberties Alliance. Richard, excellent representation. I got to tell you, very, very just fantastic. Your name was moved around in the Gun Rights Policy Conference in Phoenix last weekend, very favorably. So we appreciate you being on Gun Radio Utah. Thank you.
Well, my pleasure. We'll talk to you again soon.
All right.